Voice 6 from the Courtroom Voices series from AAA Insolvency. So the original judgment is from High Court of Karnataka, and the Supreme Court has stayed this judgment on 17th of May 24. So the case is very important because you can understand how the senior lawyers were appearing. Mukul Rohtagi, Senior Advocate Dr. Abhishek Manu Singhvi, Senior Advocate Mr. Dhruv Mehta, Senior Advocate Mr. Tushar Mehta, Solicitor General of India, Parag Tripathi. So they were all appearing in this judgment, so that means the judgment is very, very important. This judgment was basically providing a stay on the judgment from High Court of Karnataka at Bengaluru, which was dated 22nd April 2024. And the applicant in this case was Farooq Ali Khan, the director of the corporate debtor, and the respondents were Punjab National Bank, Union Bank, and various other parties, even the IBBI, even the ICAI, all was these basically the respondents in this case. The company was Associate Decor Limited. Company was established in 2007 and a lot of loan acquisition was taken, and finally this lot of credit facilities were there, and in this account became NPA in 2016, and the disputes amongst the promoters in fact led to this default. The CIRP started under section 7 from Punjab National Bank, and it was started in February 2020. Now the resolution plan was submitted on February 2020 and also on the February 2011. The meeting of the Committee of Creditors, in fact they approved the resolution plan and it was submitted to the NCLT. The resolution petitioner offered 280 crores and the settlement of the statutory dues of the operational creditors, which was much higher than the 243. The resolution plan which was approved, that was for 243 crores. However, the petitioner, the ex-director of the company, offered 280 crores. So the difference is much, 280 crores and 243. So that is the difference. So the basic dispute is that the resolution plan was not approved by NCLT, and even before that this kind of petitions started from another petitioner who is the director of the company, who is the promoter of the company. The total claims in this company was 700 crore, and the offer which the resolution plan of 243 crore was approved, and the resolution plan of 280 crore was not approved. That was the decision of the Committee of Creditor, which was being challenged, and the COC approved the resolution plan of one Muhammad Enterprises in bracket Tanzania Limited, that was approved on February 11, 2020. In this case, the applicant argued that the higher offer was ignored by the COC, which was at 280 crores, and the offer which was approved was at 243 crore, that was from Muhammad Enterprises in bracket Tanzania, that was rejected. And also the applicant contended that when this resolution plan was approved, the notice was not given to the promoter, because he was also a member of the Committee of Creditor. That notice was only given for 3 hours, and in that particular meeting the resolution plan was approved, and it was violative of regulation 19 of the IBBI, and therefore the principle of natural justice, the applicant, who is the promoter of the company, claimed that the approval of the resolution plan is without any proper notice and it violates the principle of natural justice, although he is not having any voting rights. But yes, promoter arguing that he has a right, he was not given proper notice. His resolution plan was not considered, which was offering 280 crore. Another resolution plan which was only offering 243 was approved. Now the COC's commercial wisdom. The respondents argued that that is supreme. The COC's commercial wisdom is supreme. Then again it was said that the finality of the proceedings, the respondents in fact maintained that the proceedings had attained finality with the approval of the resolution plan and subsequent legal endorsements. Now let us understand the legal issues involved. One is the validity of the notice. The short notice was given for an adjourned meeting. Therefore, this was also one of the issue, and therefore it was considered as violative. The judgment is based on the Article 226 and 227 of the Constitution of India, and the other sections which were in fact violative, the referred in the case was Section 7 of the IBC, Section 24 of the IBC, and also Regulation 19 of IBBI regulations. So now, what are the issue? The issue is that the promoters were not given the promoters. They were not in the meeting. They were given notice of only 3 days. Their resolution plan was higher at 280 crore. The resolution plan which was in fact approved was much lesser at 243 crore. So therefore, the High Court of Karnataka finally passed an order that this resolution plan should go back to the Committee of Creditors, and the Committee of Creditors should reconsider this resolution plan. So, and that too after so much of period. Look, the resolution plan was approved in 2020. Now the High Court of Karnataka says that it is stayed because an application was submitted by the promoters that his resolution plan was higher. Secondly, he was not considered, he was not given proper notice, and he was given only 3 hours notice. So therefore, the emphasis is on the procedural compliances. The judgment reinforces the need for strict adherence to the procedural requirements of the insolvency process. Rights of the suspended directors cannot be ignored. It also underscores the importance of ensuring that the suspended directors are given adequate notice and opportunity to participate in COC meeting. Now the judicial scrutiny in this case says the highlights of the case is that the procedural lapses in the insolvency processes, promoting fairness and transparency is very, very highlighting things. Now the conclusion is that the High Court's judgment, which was a month back in April 24, which is now stayed by the Supreme Court of India, in that High Court judgment, the High Court actually says that the lapse, that the only 3-hour notice was given to the promoters. 2, that the promoters' offer was much higher than the other offer. So therefore, the High Court says that it should go back to the creditors, and the creditors must consider that. And this appeal before Honorable Supreme Court is against that order of High Court of Karnataka, which says that this resolution plan is not approved, it should go back and it should be reconsidered. So now the Supreme Court has stayed this. Supreme Court has stayed this, and now let us see what happens in the Supreme Court. In the meantime, what is the message in this particular judgment? The message is, 1, that the promoters are important, they should be given proper notice of the meeting. In case the notice of the meeting is not given, I think that is a very good argument in their lap that they can use any time that we were not given notices. Secondly, their offer was 280 crore and another offer at 243 crore was approved by the Committee of Creditors. We will have to see what finally Supreme Court says in this case, but this actually is very important on the powers of the promoters. They have dragged this case, and they actually would see that this actually will become a landmark judgment whenever Supreme Court decides for this course. Thank you very much.